All right, Melissa Paez. Norma, on this case, it's set for sentencing. State, this is Melissa Paez. It's set for sentencing, but defense counsel is out of county on another matter. So is everyone okay? It's an opposed offer. I don't know. Did you all have witnesses?
If we're not opposed to it, we were exactly what it is.
Okay. All right. So we won't be able to do it on Friday because I have a mental health docket.
Okay.
So if you can speak with Ms. Ferguson and you all come up with a date. So we're just trying to get a date for your attorney to be here, okay? So if you'll confer with her and then let me know what date y'all have decided on.
Yes, ma'am. All right. Thank you, Judge.
Thank you.
Thank you. I just make sure what the calendar looks like for next week. Thank you.
All right, anyone else ready?
Yes, it's on the page.
Jameson Franklin.
Your former. It used to be my guy. He upgraded SE. Can I have one more?
Court is calling 2025 CR 004-587 State versus Jameson Franklin. Could I have parties announced?
And Jonathan Alvarado for the defense.
And are you Mr. Franklin?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision with your attorney? And did you understand it?
Okay. So, Judge, I apologize. I have not gone over the First Amendment with him. Just I show it to it real quick.
Okay.
This was what we found on the other case.
Can you do it on like the third or something? Yeah. Wait, let me just check. Just 1 second. Oh, I'm sorry. Off the record for a moment. All right, the second is fine. Yes. And we're back on the record, Cindy.
Okay. I know.
Right, no, that's what I'm saying, but just so you have noticed it was.
Okay.
No. All right. So, Mr. Franklin, did you have a chance to review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney?
Yes, yes.
And did you understand it?
Yes, yes.
Are you the same Jameson Franklin who was placed on community supervision for the offense of manufacturing delivery of a controlled substance penalty group 1, 4 to 200 grams on July 24th, 2025 for a term of 8 years? Is that you?
Yes.
All right, state.
On State's First Amended violated condition number 1 on or about the 3rd day of December 2025 in Bear County, Texas. The defendant Jameson Robert Franklin committed the offense of possession of controlled substance or violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated.
Well, I mean, if he's pleading not true, today is supposed to be set for a contested. Are you all?
So
Do you want to?
I apologize, Judge. I didn't know exactly what the court wanted to do today because this is actually a First Amendment we were just handed today. These are new offenses that happened. I think the offense date is on either Monday or Tuesday of this week. And so I was going to ask the court for a reset at this point because of the new allegations. Additionally, Judge, I was not appointed onto the new cases. So I do not have the discovery as of yet.
So from the allegation, that's not the amended motion, but the original motion, the allegation of possession dated from December 3rd, 2025, you don't have discovery on that?
No, Judge, I do have discovery on that. I am the attorney appointed on that case. I would just ask for a reset, Judge, because at this point, with the new offenses, I think it would be, for all parties and the court, it might not be efficient to try and proceed with those cases, the MTR today, when potentially we could wrap all the cases together. And I've conferred with the state on this, and that was kind of our approach to it, Judge.
So when is that going to be accomplished, if that is accomplished?
Well, I would need to get on the new cases or get the discovery in the new cases. So as soon as that could be done, Judge.
And are the labs in for the,
So, no, Judge, and the types of charges that the new cases are, we would not be able to proceed on the drug at this time because the turnaround for the testing, but there are two other cases that would potentially be able to be proceeding with the.
all right, and the other two cases,
It's a theft and a fraud use.
do you have discovery on those?
I do not.
All right, so he needs to have discovery on those. And Norma? Yes. This will be the last reset for this case. Set this for a contested hearing in 3 weeks.
Okay.
And just, for opinion, is Roger Bettis, so I'll contact Roger Bettis and see if I can just put Jonathan on there
Okay.
and just take him off.
Thank you.
They're assigned to.
That works. Thank you.
I didn't assign.
Yeah.
3 weeks, Judge?
Yes.
That would be March 19th.
March 19th? Okay.
Okay. Thank you, Judge.
You're welcome.
Sorry for the confusion.
Oh, no problem.
Yeah. Well. I'll get back to you on that. So, is this okay? I don't know. We know who to go over it once more. Yes, sir.
Okay. All right, you want to step back?
Um,
Go over things?
I'm sorry. So you want to talk to me further about signing this, or you want to talk to the judge about the next part? It's up to you. I would like to talk to Mrs. Boyd about the next part. Okay.
Okay, talk to me concerning what?
The certification of right of appeal, we're gonna ask for a contested motion to revoke.
Mhm.
My client understands he's gonna plead not true to the allegation, one of the allegations. But it's about signing the trial court certification of right of appeal. I've circled, it's not a plea bargaining case. He still does have.
Here's the thing. I would love for attorneys not to check boxes because I decide whether he can appeal or not. And I don't know what I will do in this case. And I don't know if y'all have reached an agreement whether or not he would waive his right to appeal. So I'm in charge of checking boxes. So if y'all could tell attorneys on trial court certification, please do not check boxes because then I have to scratch things out. So now, with regards to the motion to revoke, this is what I'm going to explain to you. This is a contract with the court. If you want a contested hearing, what that means is the state, whatever allegations they're saying that you did or whatever rules they're saying you violated, they'll have to bring in witnesses to prove it. Do you understand?
Yes, sir.
All right. So do you want a contested hearing?
For the harassment allegations, yes, ma'am.
All right. So the only thing that I have in the,
Trespass, apologies.
yeah, the only thing I have in the motion to revoke is an allegation that you committed a criminal trespass and the use of marijuana. Those are the only two things I have.
Yes, ma'am.
Okay.
Excuse me, Ms. Roy, is it possible to only contest one of those?
That can be up to your attorney if that's what you want to do. Yes, you can plead true or not true to whichever allegations you want to plead true to.
Yes, ma'am.
All right. So let me ask you all this.
Yes, sure.
What is the plans for, what is the recommendation?
Recommendation from the states to revoke the law.
All right. And so I only have two allegations, criminal trespass
Well,
and marijuana.
there's gonna be an amended one coming. I need to be in completion because there's gonna be two number ones added to the MTR for the cities.
All right. And in the amended allegations, what are the allegations?
Two charges of harassment.
Okay. So then what we'll need to do is number one, is that going to be filed today?
I need to probation as soon as I can tell you so they can, there and get the amended.
All right. So they're telling me that they're going to amend the motion to revoke. So what that means is they're saying they're going to add more allegations other than the criminal trespass and the marijuana. They're telling me they're going to add 2 allegations of harassment. I don't know anything about these allegations. I won't know until somebody presents some evidence to me if they do so. But in regards to motions to revoke, you can plead true or not true to any allegation you want to. So that means you don't have to plead true to everything. You don't have to plead not true to everything. It's really up to you, hopefully after the discussion with your attorney. All right, so what I'm gonna do, I'm going to reset it. And I'm going to reset it. It's gonna be reset for a contested. If it turns out you've spoken to your attorney and you decide not to contest, your attorney, I'm gonna ask that you let probation know because they'll have to have witnesses here. And does everyone want the witnesses in person?
Yes, sir.
All right. So, Ms. Ferguson, can you set this for a contested hearing? And what we'll set it for, we'll set it in 3 weeks. And so that'll give your attorney 10 days, well, more than 10 days.
March 19th.
Yes.
All right, so March 19th is going to be your contested hearing.
Yes, ma'am. Judge Boyd, while I have you, can I ask a question?
Sure. Now, whether I'm allowed to answer that or not depends on what the question is.
If I wasn't informed that further contact would lead to a harassment, are those amendments to the?
Okay, so this is what I'm going to tell you. Because you're asking me about the allegations in the motion,
Yes.
I'm not allowed to give you the law on that.
Okay.
You have to speak to your attorney because once I start commenting, because it sounds like you're trying to raise some sort of defense to me. And if no, the question you're actually asking me is sort of a defense. And that's, if I answer your question, I'll be commenting on the evidence and that may make it seem like I'm not being objective and open. So that's a question you'll have to ask your attorney. So any legal questions of that nature, be sure to talk to your attorney about it and he'll give you the law on it, okay? All right, any other questions?
No, thank you, Judge Boyd.
You're welcome. So we'll see you back on March 19th. That'll be a contested hearing. If you discuss things with your attorney and you decide not to have a contested hearing, he'll let probation know so they don't have witnesses. Okay?
Love your flowers.
Oh, thank you.
Yes, ma'am.
They brighten the room. I think so. $20.
In case 1, the judge firmly addresses the defendant regarding courtroom punctuality and procedural expectations. What might seem like a minor issue arriving late quickly becomes symbolic of respect for the court. The judge's tone is controlled yet unmistakably serious. By clearly stating that court begins at 9 a.m., she reinforces structure and discipline. This moment is not dramatic because of shouting or chaos, but because of quiet authority. It demonstrates that deadlines and courtroom decorum are not suggestions, they are foundational to the justice system. The subtle tension lies in the fact that plea negotiations had reached an impasse and the window for compromise had effectively closed. Once the plea deadline expired, the case shifted toward trial, raising the stakes significantly. The judge's refusal to entertain further plea bargains without good cause underscores accountability. Case 2, involving Jessica Cantu, presents a contrasting emotional tone. Charged with possession of a controlled substance, she faced up to 2 years in a state jail facility. Ultimately, under a plea agreement, she received 1 year in the Bexar County Jail and an $800 fine. Yet what makes this moment compelling is not the sentence itself, it is the judge's compassionate response afterward. Although jurisdiction would end once the plea was accepted, the judge still instructed staff to seek treatment resources for her, including assistance related to Haven for Hope. This brief act of concern added depth to the proceeding. It showed that justice is not solely about punishment, but also about offering pathways to rehabilitation.